All right, welcome. We are back in session. My apologies for the sort of extended recess, but it is very important that we comply with the timelines that are set out in the agenda. So if I seem like I'm a stickler or hard-hearted or whatever other phrase you deem to call me, that's okay. I've got to stick to the timelines. So we have guests. And I know Phyllis Lykin, center of the table. Phyllis, I'm going to have you introduce everybody, but before I do that, I just wanted to sort of welcome you here. This is the governing body of the Washington State Bar Association, also known as the Board of Governors, or the BOG. You know that already. We're here really sort of, just to set this up, to tee it off, it's an informational session. Phyllis is a longtime court reporter here in Yakima and actually around the state. Taken a lot of depositions, not just for me, but for a whole host of attorneys. Some issues have come up on her radar screen. She shared those with me, and I thought it would certainly be of interest to this board to, at a minimum, be aware of what's happening in the court reporter world, because oftentimes we rely on their services to a great extent to help us do the work that we do. And we find ourselves working in collaboration often, so it's very important. With that said, Phyllis, I'll have you introduce the team that's here. Oh, go ahead. Yeah, sorry, Margaret. You got to check. Okay. Margaret will make sure we've got folks on the line. Thanks, Margaret.
Welcome to the Washington...
After the tone, please say your name, followed by the pound key.
Public session.
Your call has been placed in conference. You are the first caller to join the conference. Please wait for further participants.
You may hear people adding on to the phone, which is fine. Generally just pause. Let them get on. I'm thinking somebody may add here soon. We'll go ahead and start. So, Phyllis, if you'll introduce the team. And again, board members and staff members present. This is informational at this point in time. There is not some big ask in front of the board. It is not on for action. This is simply informational. Phyllis.
And thank you for allowing us to speak with you today. Behind me is Wendy Raymond. She's the president of the Washington Court Reporters Association.
Welcome, Wendy.
Beside me is Liz Harvey. She is a co-chair with me on the legislative committee.
Welcome, Liz.
And beside me is Brad Axel. He is WCRA's legal counsel and has been for about 12 years.
The lawyers in the room. All right. Good. Welcome.
Okay, well, I'll start things off this morning. As Phyllis said, I'm Liz Harvey, and I am one of the legislative co-chairs. And the genesis of our presentation today is two requests that we're thinking about making and issues that we want to discuss with you that Phyllis initially spoke with Mr. Pickett about, and as he said, now we're here to kind of discuss all of this with you and present it to you, and so you know what some of the issues are that we're dealing with. The two requests that we're thinking about today, or issues that we're thinking about today, the first one you will find in tab 1 of your binder, I shouldn't say your binder, but the information that I think you all have already received that we put together for you.
That's on page 3, starts on page 354. Go ahead, Liz.
Okay, thanks. And the language that we're requesting, first of all, or considering requesting, is a rule change to Rule 30. And that would allow court reporters in Washington certified court reporters, to swear in witnesses remotely when they are not present with the witness. And it's very important as we go through that you remember that we're speaking only of Washington certified court reporters, because we are certified, regulated by the state. We're accountable to the public, to the courts, and to all of you. And there are issues arising within Washington and nationally where there are some efforts made to do an end around those regulations and send people who may not be qualified and may not be accountable or regulated and are covering depositions for you. We're considering adding this language for a couple of reasons. One, I'm sure you've all run into the problem for those of you who take depositions where all of a sudden you don't have a court reporter. Somebody forgot to order them, or they got in a car accident, or whatever may have happened. It's also, we think, would be helpful for remote locations where someone lives in a very remote area, especially in the eastern part of the state, and it's really cost prohibitive to pay somebody to drive a couple of hours to take a 30-minute deposition. So this would allow for the court reporter to be on the phone, the witness to be in their location. For a Washington case, a Washington certified court reporter could then swear the witness over the phone and proceed with the deposition. Another reason that we're looking at this, and Phyllis and Brad will both share more about this with you, is that, as I mentioned, there are some firms that we're concerned are circumventing our court reporter certification laws, which puts the consumer at risk and puts your deposition transcript certification at risk. And one of the things that they may often do is at the last minute be unable to provide a reporter for you and instead send a non-certified person, many times a notary public. That brings me to the tabs 1 through 3 all sort of give you a background on why court reporters are certified to swear in witnesses. We don't need to be notaries. We haven't been notaries, most of us, since 2010. And yet all of the notices that we see almost all still say notary public. So in 2010, the RCW was changed to allow court reporters as officers of the court to swear in witnesses and administer oaths. In 2016, we went to the Supreme Court and got that same language changed in Rule 28. So that, again, allows certified court reporters to swear in witnesses as officers of the court. And in last year, in fact, the notary rules were changed, or the notary law was changed, that notary publics are specifically prohibited from providing court reporting services. So your notices shouldn't say notary public, because notary publics, number one, are not authorized to provide court reporting services, and number two, they do not have the training, certification, or qualification to provide court reporting services. So when you have a notary public, that's opening the door that you may have a non-certified, non-qualified, unregulated person covering your depositions. So we're here to ask you for two things. And as Mr. Pickett said, it's not a direct ask today, but it's something we want to have on your radar. We want to discuss this further with you. And that is that, number one, please emphasize that let's change the deposition notice to comply with the court rules and with the law, and they should all read certified court reporter. Notaries may not provide the protection that you need. And the second thing is for the rule change that we may be bringing before the Supreme Court. This may not be the final language. We'll certainly work with you on that when we get to that, and we hope that you'll support that change when it comes time. And now I'm going to turn this over to Brad very briefly, and he'll give you a little bit more of an overview on some of the issues coming up in the profession that affect your clients and us as well.
Thanks, Liz.
Good afternoon. As Phyllis said, my name is Brad Axel. I've been outside counsel for the association for a number of years, and my role here is to kind of set up some of the more substantive issues that Phyllis will be discussing about general but very concerning trends within the profession, really both professions, both lawyers and court reporters, because the two professions are very aligned, and I'll go over some of the ways we are similar, court reporters and lawyers, and then briefly talk to you about how generally the business aspect of our professions differs somewhat, and it's those differences that are creating some of the issues that we are seeing today that are extremely troubling and threaten the integrity of the entire legal system. So just briefly, how are court reporters and lawyers the same? Well, as Liz said, court reporters are officers of the court. Most of you are as well as lawyers. We both need to pass a professional test to achieve licensure. Lawyers need to pass the bar. There is a proficiency test that court reporters need to pass to become Washington State certified court reporters. once you are a certified court reporter or a lawyer, you are also subject to a list of professional standards and regulations and codes of conduct. In the case of lawyers, those are found primarily in the RPCs. In the case of court reporters, they are in the Court Reporting Act and the RCWs, as well as the Washington Administrative Code. And so all the court reporters in the state, of which there are roughly, Phyllis can correct me if I'm wrong, about 550, all of those court reporters are subject to those regulations and those professional standards. And if they fail to meet them, their license is at risk, and they are subject to a host of other disciplinary penalties if they don't comply. There are also regulations built into those standards that impact the business side of our profession. In the case of attorneys, all of us are obligated to only charge our clients reasonable attorney's fees. That is found in the RPCs. In the case of court reporters, there are regulations within the WAC about the makeup of a deposition transcript. So court reporters that are certified in this state are subject to those provisions. Court reporters that are not certified by the state don't necessarily abide by the provisions, and that directly affects the bottom line of attorneys and clients who are purchasing those services. So, all of a sudden, a 100-page deposition transcript can be altered to become a 150-page deposition transcript, thus jacking up the price of the product. So those are all the ways in which reporters and lawyers are similar, but when it comes to the practice of our professions, it starts to differ dramatically, and those differences, I think, are what are causing some of the issues that we're seeing today and that Phyllis will talk about. But in general, when we are retained by a client, as lawyers, both we and our firms are subject to all the regulations that go along with that. And we are also subject to all the regulations of the jurisdictions in which we practice. So if I have a case in California, I need to go to California, hire a local counsel who gets me admitted pro hoc vice in that jurisdiction, so I become subject to that jurisdiction's regulation. That is dramatically different than what is happening in the court reporting world. In the court reporting world, a large national reporting firm, maybe located in Texas or New York or Florida, contracts with either a large firm out of state or perhaps directly with a litigant, a large insurance company, for example, and they have an agreement that spans multiple cases on what they're going to receive as compensation for their services. That out-of-state court reporting firm is not subject to any regulation by either the WAC or the RCWs or the court rules, because all of those things only apply to certified court reporters. So the out-of-state firm then hires, as an independent contractor, a court reporter. That court reporter, to the best he or she can, complies with the regulations that they're subject to, but at the end of the day, the transcript that is being purchased goes back to the firm, and that firm ultimately decides when the litigants receive it. And I just had a recent experience with that, where the large court reporting firm, I ordered a transcript expedited the next day, as did the other side who had retained the court reporting firm. They received it. I didn't receive it. My suspicion is there was some kind of contract that spanned multiple cases. But that's just one example of how court reporting impacts the practice of law. Another example, which Phyllis will discuss in more detail, is prices. There's an example in the materials that the association has provided where a court reporting firm said it was charging the same to both parties, but it wasn't. It was charging more to one party and less to the party that it had a ongoing contract with. So the profession of court reporting is dramatically different than the profession of lawyering when it comes to the business aspect. And what is happening is these large national firms are gobbling up more and more of the business, and they are becoming more powerful, and they are completely unregulated, whereas the court reporters in Washington who have gone through and obtained licensure are now finding themselves more and more under the thumb of those large national firms. And that is going to impact all of our practices, and it's going to impact the integrity of the legal system in Washington State as it has in other places. So with that, I'll turn it over to Phyllis, who has more specifics to add.
Thanks, Brad.
So, pursuant to CR 28D, there's supposed to be equal terms required for all parties as relates to court reporting services, and also 28C in both federal and local rules include disqualification for interest rules, whereby depositions are not supposed to be taken before a person who's a relative or employee or attorney or counsel of any of the parties. And we think that the line is being crossed as to who's an independent court reporting agency if they're actually contracting directly with party litigants. It's something that's occurring more and more, unfortunately. And so the Washington Court Reporters Association has attempted to get firm regulation in to the RCWs, and also has attempted through the Supreme Court to seek more regulations or court rules that prohibit the practice. So we had a certification of court rule and WAC compliance drawn up that court reporting firms are asking, and court reporters are asking firms who are engaging in contracts to sign, stating that they will be complying with our court rules related to disqualification for interest, equal terms required, and offering arrangements on a case for all parties on equal terms. We asked that the Supreme Court make it possible, if attorneys so desired and suspected they weren't being treated equally, that they could seek a affidavit of equal terms. The Supreme Court at that time had 2 pending lawsuits in front of them, and did not go with our suggestion for amending the rule. So we created this certificate of court rule and WAC compliance for court reporters, but also attorneys could ask that the same thing be signed when they're engaged in lawsuits where they think that there could be unequal terms being applied. So I also included in the materials an article related to contracting. The National Court Reporting Association and the Washington Court Reporting Association does not condone contracting. It in fact says the opposite, that we should not be engaging in contracting with any of the parties or third-party litigants in the lawsuit. And NCRA defines contracting as any entity that provides or arranges for court reporting services, entering into an oral or written contractual agreement for more than one case. There is legislation in approximately 28 states that it's addressing contracting, because oftentimes the noting attorney's right to select a court reporter of his or her own choosing is restricted by the party litigant. There's networking that's happening between the firms, because nationwide firms, of course, don't have court reporters or offices in every city in the country, which they sometimes proclaim. But instead they contact local court reporting firms or local court reporters to cover their work. So if a firm used to call a local court reporter, they're now calling a firm in New Jersey, and you're wondering, why is there a firm in New Jersey taking this deposition in Yakima, Washington? That's why, because they have been directed to contact the one firm that they have provided a contract with. And unfortunately, court reporters have always been regarded as the only neutral and unbiased person in the room at depositions. So given the public's belief in neutrality, contracting becomes egregious when the consumers of court reporting services are unknowingly subjected to these exclusive contractual arrangements between a party of interest and a court reporting firm. And like Brad said, sometimes one party is given a discount and the other side is not. Sometimes one party, especially when it's critical, and it happened to my own firm only weeks ago, There was a motion for summary judgment coming up. The transcript was produced. It was given to the firm. And one side received it, but the other side did not, not only for the motion for summary judgment, but on the following Monday, there was a mediation scheduled, and they didn't receive it for the mediation either.
Phyllis, I apologize. I need to pause you for a moment. The governor's on the phone. Would you please identify yourself? Brian or Jean?
Hello?
Okay, Brian. Thank you, Brian. Jean, are you there? Okay, Brian is there. Jean is not. How many do we have? Sorry, it's a board.
We have 9. We have 9. Is that sufficient?
Needed to verify our quorum was still here. All right. Continue. Thank you. Sorry.
I wanted to jump in there so the scenario that Phyllis is describing is one that involves a national court reporting firm subcontracting with Phyllis to do the actual reporting. If you compare two scenarios, one in which Phyllis's firm is hired to do the reporting directly by one of the counsel or litigants, the firm and she are under an obligation under the court rules to provide equal terms and can be subject to discipline if those equal terms aren't provided. In the scenario that's being described, the court reporting firm has subcontracted with Phyllis to do the court reporting. And so the transcript goes back to the court reporting firm. That court reporting firm, which is not subject to regulation of this state, then decides whether the parties pay the same price for the transcript and also decides whether the parties receive the transcript at the same time. And that is the problem here, is we have a regulatory regime that applies only to in-state reporters and is completely absent from these large national court reporting firms.
That's correct. I did provide in the materials a resolution from the American Judges Association, and they state that when court reporting firms are contracting directly with parties in interest in litigation, it circumvents counsel and their related ethical obligations to the courts. And WCRA has the same concern. We feel like our ethical obligations are also being circumvented, and our ethical obligation to be neutral. We've attempted to enact anti-contracting laws. We've attempted to run through the Supreme Court to make a difference that will impact this practice.
No names are available.
When that happens, there's some nationwide firms who have banded together, and they fight not only legislation in Washington State, but all across the country. And I included within the materials a PDC filing that identifies the firms and that they've formed a separate corporation to fight any legislation that prevents this practice. And, you know, some people ask, and kind of the run at the legislature is, hey, we're trying to save money here for parties by offering bulk deals. So what's wrong with that? Other companies offer bulk deals so that they can offer merchandise on reduced prices. So, for instance, Walmart might have a blue light special, and everybody's directed in. They want to get the lowest price TV, lower price than other people can sell it in town. But the difference between this and court reporters, which, first of all, were not commodities, but secondly, everyone who goes to Walmart for the discounted bulk rate TV pays the same amount. There's not some people who pay a lesser amount, and that lesser amount, the difference is then heaped over onto another consumer of the product. And that's what's happening in this industry right now with firms who are contracting with directly with third-party litigants or insurance agencies. I'm not saying it happens in every situation, but we're being made aware of it by our clients who are upset that all of a sudden their copies of depositions are costing so much more than they used to. They're not understanding why. So I included the contracting article that kind of capsulizes what contracting is about. And there, you've got the PDC form that shows that companies are banding together to fight individual court reporters and court reporting associations, and they're also suing court reporting associations. And there is a lawsuit that was filed in Washington State in King County called Kendall Baker versus U.S. Legal. I included that documentation within the documents. And there, before I was able to become aware of it, there's been a settlement recently in that case, and Wendy has that in case anybody wants to view the settlement agreement that happened. So she's going to hand that out for you. And so what's happening? Some of the nationwide firms are claiming that there's a shortage of court reporters, and there are a shortage of court reporters that are willing to work for some of those agencies, mostly because of discomfort with abandoning the ethical obligations that we have. So they're actually recommending that on your notices you should add it will be taken before a certified court reporter or digital or audio or other means. And that's happening kind of across the country. And you can ask yourself, you know, some of the courts use digital recording for transcripts, and we all have probably seen the transcripts are fraught with errors and inaudibles and other things. And that's through digital equipment that the courts have paid millions of dollars for, quite frankly. And in the best of circumstances, and they're actually operated by someone who is employed by the court system, and they provide those digital files for transcriptionists or court reporters to transcribe. GR 35 requires when there's an audio, transcribers must certify that they received the electronic recording directly from the trial court conducting the hearing. In depositions, there's no such chain of control requirement. Digital reporting is entirely unregulated in Washington and any other state. It's actually prohibited by the RCW.
No names are available.
By the RCW regulating court reporters at this time. So because of that, WCRA, along with NCRA, is not condoning the practice of introducing digital reporting / recording in depositions as an alternative method. We think that adding just one more aspect to the rule that would allow for remote reporting, where you still have a certified court reporter who is recording a transcript and is solely responsible for the chain of control of the transcript, is what we're recommending for the lawyers across Washington State. The standards of practice, and I'll wrap this up, the standards of practice for court reporting, it's WAC 308-14-130, does ask and require that all offer arrangements on a case concerning court reporting services or fees to all parties on equal terms, just like CR 28D. And it also requires that court reporters provide transcripts on agreed delivery date and give notification of delays. And they're required to preserve the confidentiality of all information during a proceeding and take all steps necessary to ensure the security, notify all parties when transcripts are ordered. And with digital reporting that's completely unregulated, they are not subject to any of these standards of practice, not confidentiality, not anything. So then you have to wonder who has access to your clients' trade secrets and other company information, because sometimes the digital recording audio files are being sent overseas to be transcribed at a greatly reduced rate. So that's basically our information that we wanted to impart to everybody. They did find in California in a case, Moose versus U.S. Legal Support, U.S. Legal Support claimed they did not need to adhere to the court reporting rules and regulations there. The appellate court found otherwise and deemed that they are practicing court reporting service, even though they're a firm owned by someone other than a court reporter, I think. I'm not sure who owns them. What I wanted to suggest going forward is that there be a liaison, and I would volunteer to do that, or Liz and I together could do that as a liaison between the WSBA and the Washington Court Reporters Association, so that we can address these issues as they come up, because for many years, court reporters have been in fear of speaking up about some of these issues because they fear blacklisting and retaliation. So that's the reason that we're here and advising you, and we look for your support in the years ahead, as we're anticipating Court Reporting Practice Act is going to have difficulties in the future ahead, because some of the nationwide firms in other states are looking to dismantle Court Reporting Practice Act across the country.
I would just add that I think, at a very high level, with the digital reporting that Phyllis closed with at the end there, I mean, that's just a straight-out effort to get any person that's subject to professional responsibility out of the room, and eliminate any obligations whatsoever from the practice of reporting. And the general trend, I mean, and the reason some of these firms, these nationwide firms, are receiving private equity funding is because they see a lot of dollar signs, and they see people that are subject to a professional code as an impediment to those dollars, and that's what's happening. And other states have fought it more vigorously. I think what the association has seen is this fight is going to evolve very quickly, and more of this type of behavior is happening, and it's happening all over the country, and so we just need to be ready for it.
Thank you very much. Appreciate all of that insightful information. I just will stress to the board, if you have questions, and you may not have questions because this just came on your radar here recently, but if you do have questions, we can take a minute or two of questioning. If you don't have questions, I want to just say this, that one, I think we do need to explore this idea of a cooperative liaison back and forth, because the issue of the reliability and the integrity of the deposition process is what's really at the core here, for, at least in my opinion, and significantly potentially impacts the administration of justice. And I would hope that we can protect that integrity by working in a collaborative fashion with our certified, outstanding Washington State court reporters in some form or fashion. So, any questions, governors, at this point? Any questions on the phone? Okay. Hearing none, do not take that silence as disinterest. Take that as folks who are going to actually cogitate and think carefully before they speak, unlike their president, who does quite frequently. Again, on behalf of the State Bar Association, thank you, and then we will continue to let this percolate. Phyllis, Brad,
No
Liz,
names are available.
all of you, thank you for being here, and we will hope to get back to you soon, especially with the idea of this liaison back and forth. All right?
Thank you for having
Thank
us.
you very much. All right, next on the agenda. Everybody says the word lunch, like I wasn't going to say lunch. They're all assuming I just don't read. It's got lunch from 12 to 1. That's going to be in this room. Ethan?
Can the record reflect the governors that are missing from the room? Because there were a number of folks gone.
Okay, sure.
So, and I know just entering the room, I know Kyle just joined us, but gone. So Kyle just joined us, but Carlo's gone. Dan Bridges is gone. Paul Swiggle is gone. Is anyone else missing?
And I think Jean was Jean on the phone or not? It was just Brian. I know Brian's on the phone.
I just know we have quorum requirements.
Yeah, I'm
we
on the
checked.
phone.
We checked. Yes.
I've been listening.
Yes, thanks, Brian. All right. So we are back at 1 o'clock promptly to start our the session, and we'll be discussing a board update surrounding communications. And I see that Bill Pickett and Sarah Nagowski and Tara's not on there, but I know she's on there. We'll have a discussion surrounding that right after lunch. So 1 o'clock, we'll be back in. We stand in recess until then. Thank you.